Hey, happy day before Thanksgiving, everybody. Wow, breaking news last night and this morning on that new overtime rule, which is technically now not an overtime rule due to an injunction ordered by a Texas federal judge. That was actually a pretty big surprise to me. In fact, our general counsel with Carrozza Law, Tony Carrozza, and I were just talking on that subject, one of the topics last week for a group, and actually spent a little time this morning talking about that. And boy, I think one of the quotes I think he read in the Wall Street Journal was that sure does leave a lot of employers in limbo. And there are articles all over the place on this right now. It's one of the top trending subjects because this order comes in late yesterday afternoon, we're the day before Thanksgiving when a lot of people are already out of the office. Everybody's getting ready to be off for a while. And originally, the new overtime rule was to go into effect as of next week, Thursday, December 1st. So, what the heck do you do now if you're an employer who's already done all your preparations to be in compliance by December 1st? Tony read a really funny clip from an employer who said he had about 81 employees and was rewarded through procrastination on this particular issue. And if you are not rewarded by procrastination as an employer, now what the heck do you do? Do you roll back any possible salary increases you gave? Certainly, everybody's looking at that going, man, you're going to make a lot of employees really unhappy if they just received a salary increase to be compliant. And now, are you going to really risk that and take that away and really make them unhappy? And what about hourly employees, people that you decided to move from exempt salary to non-exempt or hourly, and now certainly they're not going to earn that overtime. But again, as Tony and I had talked about, the way this was really sold and communicated was that it was going to make additional earnings available for a lot of people who otherwise don't get it. And that really truly is a misnomer. That's really not the case. And in fact, there was an article way back in May of this year published. It was written by Alan Smith, JD, for SHRM, and I think the article title was Overtime Rule Issued, Salary Level to Increase Every 3 Years, again by Alan Smith, JD. In that article, he actually provided a quote from attorney Paul DeCamp, who I believe is of the Jackson Lewis law firm. And he was, Paul DeCamp was actually a former wage and hour division administrator, who that particular division of the Department of Labor who's looking very hard at this rule. He was quoted in that article indicating that this overtime rule is not and was not put in place to make employees rich or actually really truly increase their earning power. The idea behind that was rather, and this is quoting from that article that Paul DeCamp was listed in, rather to make it so expensive for employers to have people work long hours that employers will instead elect to spread the work around to more employees. So the intent really originally sounds like it was to have employers desire to hire more people, spread the work over rather than actually pay overtime, but spread that money out over more employees, employing more people. I think from what I've learned and heard from a lot of companies that I've talked to over recent months who've been preparing for this, that technically really wasn't what was happening. And I think in the judge's order, he kind of hit on that. But what really seemed to be happening was a lot of employers deciding that, maybe necessarily rather than issuing salary increases to meet that new exempt level, a lot of people were just adjusted to non-exempt or hourly, and in many cases, even hours were looking at being cut. Some companies were even looking at doing layoffs because of the large increase, and this was a significant increase that was gonna be required. and still might. We really don't know. At this point, all we know is that the injunction order has been issued, so the effective date is not, that's been stalled. This does not go into effect as of December 1st. Now what happens is we have a lot of more court time, a lot more discussion. Certainly the Department of Labor is going to issue an immediate appeal on this injunction. Certainly this could get drawn out well into January, which I think a lot of people are thinking may happen, and who knows what happens when the new administration takes over. Ultimately, because this is a rule change and not a piece of legislation, which again the judge, argued that again this was really an overreach in that because it's under the FLSA, which is a piece of legislation, Congress really should make determinations on whether increases like this should be done. That's who has the authority on this, is the judge's interpretation. But again, the judge's order does say in the scope of the injunction section, and it's a 20-page order, real easily you can actually find a copy of the actual order on an NPR article that was published this morning. But the judge says in the order, a nationwide injunction is proper in this case. The final rule is applicable to all states. Consequently, the scope of the alleged irreparable injury extends nationwide. A nationwide injunction protects both employers and employees from being subject to different EAP exemptions based on location. This court is not alone in its decision, and it cites a couple of other judgments recently that have occurred to carry that out. You can go on through and actually Google that NPR article. Or just Google the order itself, read through it. It's 20 pages long. I spent some time reading that this morning. Certainly see where the judge is coming from, the 21 states that actually filed it. But right now that leaves all the employers who prepared for this in just kind of a what the heck do we do now sort of situation. My thought, and I was actually talking with Tony this morning, our thought is if you've done all your prep, you've got everything in place, it may be best to just move forward. You may decide that might be the easiest thing to do rather than retract everything you've done, spend more time and money making adjustments, making people really unhappy if you retract salary increases or whatever it is that they've already done. It may be easier and simply at this point maybe even a little bit more cost effective to leave things in place. So we see how this plays out. It could be that this gets overturned. Then what do you do? There's always that chance. Then what do you do if it gets overturned and you've already backtracked everything? Now, would an overturning of this injunction mean that everything would be backdated to the original date, December 1st, and then you'd have back wages to pay, things to figure out. So if you've already done all your prep for it, it may be simply more cost effective to let this thing play out and see what happens over the next couple of months with it and see where you really truly need to be. But this is certainly something we didn't expect would happen this quickly. We really did think that it was going to take a little bit longer to get any kind of judgment on it. But boy, I guess this judge there in Texas was on the ball and really got on the stick with this. So now we have all of that. We all have all of this to look at here going into our Thanksgiving holiday. I do hope that everyone has a wonderful Thanksgiving and take care. Have a safe holiday, and we'll see what comes of this.